There are a number of myths floating around about your rights, the process, and what you're entitled to when it comes to separation and divorce. Today, I'm going to expose the top 10 myths in family law based on misconceptions we've heard from our clients. Number 1, the family law court favours mothers over fathers. This is one of the most popular myths, but it is completely false. In family court, there is no legal presumption that children should be cared for primarily by their mothers. The Family Law Act says that it is in the children's best interests to remain connected to both parents. Whether you're a father or a mother makes no difference. It is the case, however, that mothers tend to have more overall care of children than fathers do. But this is more often than not agreed to between the parties. The most common reason for this is that the care arrangements that were in place before separation tend to continue after separation and reflect the roles that each party played during their relationship. Number 2, that equal shared parental responsibility means 50-50 shared care. This is false. Equal shared parental responsibility refers to two parents having an equal responsibility for the making of long-term decisions in relation to a child's health and well-being. For example, health, education, and religion. Number 3, I have a right to see my child. A parent does not have any legal rights to see their child in the family law court. Rather, the children are the ones that have the right to have a meaningful relationship with both of their parents, as long as they are protected from harm and to the maximum extent consistent with the children's best interests. Number 4, I have to go to court to get custody of my kids. Mediation with a family dispute resolution practitioner is a compulsory requirement before you can file an application for a parenting order. A Section 60I certificate must be obtained and attached to your court application. There are some limited exceptions where mediation is not required, and you should seek legal advice about whether any of these exceptions apply to you. Number 5, all of the property gets divided as at separation. The asset pool does not freeze at separation, contrary to what most people think. A court must identify the current value of the assets, liabilities, and financial resources that exist at the date of the hearing or at the time of the agreement. Number 6, I earned the money, so I should get more, and she stayed at home, so she should get less. The financial contributions of each party during a relationship are considered equally important to the contributions of a party who cares for the children, to the maintenance of the home, and unpaid work such as assisting in the operation of the family business. Where one party's primary role is to care for the children, this has allowed the other party to earn an income to contribute to their super and to increase their income earning capacity. Number 7, we didn't live together for that long and she didn't pay for anything, so she gets nothing. It is extremely rare that a party is entitled to 0% of the pool, even if you live together for a very short period of time. Whether your relationship was short or long, the court must still exercise its discretion and apply the 4-step process to determining the just and equitable outcome. Number 8, we are already separated, so I don't have to pay her anything. If after separation a party is unable to support himself or herself without assistance from the other party, that party has an obligation to support their spouse where they have the capacity to do so. This responsibility exists independent of any obligation to pay child support. Number 9, I'm not separated until I leave the home. You can be separated under the one roof by sleeping in separate bedrooms, or where the behaviour of both of you makes clear that you're no longer in a relationship with one another. Number 10, I have to wait 12 months to finalise my property settlement. You can finalise your property settlement from the moment you separate, and you should do so sooner rather than later. This is different to divorce, as you have to be separated for 12 months before you can apply for a divorce.